Perfect. Hello, everybody. Thank you so much for joining us today. Today for today's seminar, Your Trust and Your Legacy, Estate Planning 101 seminar. Today with us, we have Sona, who will go over some estate planning basics, some wills and testaments, as well as power of attorney and healthcare directives, as well as a couple of other topics related to planned giving. My name is Rafael Magaña. I'm the Director of Development and Communications for Breathe Southern California, a nonprofit that was founded in 1903. We've been fighting for lung health and lung disease for 117 years, and we promote clean air. We advocate for a tobacco and now vaping-free future, as well as helping improve the quality of life for those living with lung disease. Today, our featured speaker is Sona. And let me go a little bit into your bio. I love it because it's grown since we last met. After earning her bachelor's degree of arts from UC Santa Barbara with honors, Sona received her Juris Doctorate, JD, cum laude, from Southwestern University School of Law. She has been a member in good standing with the State Bar of California since 2005, believing strongly that tax law expertise is essential to best practice in estate planning. She went on to earn a degree of Master's of Law in Taxation from Loyola Law School of Los Angeles with a focus on estate planning and taxation. Networking is a great passion of Sona. One of her many benefits of working with Lynk Law is access to her vast network of handpicked professionals. She co-founded the Exchange LA, the answer to modern networking with its inclusion of women, minorities, and nonprofits, and serves as head of the Glendale chapter. She also sits on the executive committee board of Women to Women, a networking group for professional women. This ever-expanding group of personal and professional contacts is a valuable resource that Sona is pleased to share with our clients. And a couple interesting facts of Sona: she enjoys playing board games with her family. She enjoys traveling. I don't know how that's happening during COVID-19, Sona, maybe, and baking with her daughters and reading business books. And so without any further ado, we'll start with Sona.
Thank you so much for having me, Rafael. Hi, everyone. My name is Sona Tatiyants. Rafael gave you a little bit of a background about me. I'm an estate planning attorney. I'm a certified specialist with the State Bar in this area of estate planning, trust, and probates law. I started my firm over 10 years ago, and that's the only thing that our firm focuses on is estate planning, trust, and probates law. Today, we'll be talking a little bit about both estate planning and probate, and I just want to explain to you the difference and answer any questions you may have at the end. As you can imagine, in non-COVID times, whenever I'm at a party or a cocktail party and people ask me, what do you do? And I say, I'm an estate planning attorney, inevitably, somebody will say, ooh, you must work with rich people. Because when you think of the word estate, you think, oh, somebody has a lot of wealth. So one of the things I want to demystify is that we all have an estate. Maybe our estate may not be the size of Downton Abbey's estate, where they have butlers and cooks and chauffeurs working for them, but we all have an estate. And different times of your life, your estate will differ. So for example, somebody may have, in their 20s, a car and a checkbook, and that would be their estate. Somebody in their 30s may acquire a home, may acquire a 401k once they get a job. Maybe they get an inheritance when a grandparent passes away or a parent passes away. But whenever I discuss an estate, I'm not necessarily talking about a multi-million-dollar estate. I'm talking about what you have, your possessions, whether it's your investment accounts, your cash accounts, your life insurance, your car, your home. Those all things that constitute your estate. When we think of estate planning, sometimes I know it's not the most comfortable conversation to have. So when clients want to do their estate plan, they're thinking, okay, I'll do this once and I never have to think about it again. And that's really not the right way to think of estate planning, because depending on what's going on in your life, we would look at your financial situation, we would look at your family life, and then we would look at current laws. And your estate plan, the set of documents that should protect you in various situations, would vary based on those things in your life. So somebody who is recently married, maybe they have no children, will have a very different estate plan for someone who has little ones, someone who has grandchildren, someone who has gotten a divorce, someone who's actually not married but has a long-term partner. These different things going on in your family, in your financial situation, and and the law would significantly impact what your estate plan would look like. So I wish I could ask for a raise of hand to see who has an estate plan here, but even if you are now thinking, oh, I have a will or a trust, I will tell you everybody who is here has an estate plan. Whether it's an estate plan you have seen an attorney and drafted yourself, it's like something that you have sought out to do, or you've done nothing. Even if you've done nothing, the California laws, the probate code has an actual estate plan for you. You can imagine some people don't get around to doing this, and when they pass, we need to have a plan for the courts to know how do we make a distribution of this person's assets. So we all have this thing called the default estate plan, and that's the estate plan that is designated in the California probate law. So here are some of the things that the default estate plan will have written for you. First of all, the probate code will write down specifically who gets your assets. If you don't have specifically written out, I want things to go to my favorite charity, I want things to go to my best friend, the current estate plan you have will have it written down, and it will go to your heirs. And heirs are specifically identified: your spouse, your children, your grandchildren, your parents, siblings, nieces and nephews. There's a whole hierarchy of who gets what. So if you want to do something different, that's not going to fly. So one specific thing to note, a lot of people are married with their long-term partner, but they're not officially married. Your partner, who you may have been living for a long time, even have children with, they cannot inherit from you under this current estate plan. Another thing about the current estate plan, it has a threshold under which you have to go through this probate process. I'm sure you've heard a lot about what probate is, but if your assets exceed $166,000, that's the current threshold, used to be $150,000 for a long time, your estate will go through probate process. And that actually accounts for pretty much anyone who owns real estate in California. I don't know about you, most real estate assets in California are over $166,000. So if you have a condo worth a few $100,000, you're still going through probate. And during the probate process, a judge decides what happens to your assets, and more importantly, if you have minor children, who will be the guardian of your children. So a few other things about probate. Usually, I would say it takes about 18 months. Because of COVID, we have been seeing even longer delays. We've had delays for cases that we had hearings for in April, May that have been now deferred to October, November. So I would say on average, I would even give it to 24 months to complete a probate from start to finish. What that means is while you're going through this probate process and courts are supervising the distribution of the assets, there's a delay to the beneficiaries, whether the beneficiaries are your spouse, your children. It's going to take them that long to get access to the funds that you would want to leave them. The other thing about probate, it's part of a public record. So somebody can go to the courthouse and check out the probate cases and see who's getting what. There have been even situations where real estate agents will contact our office and say, oh, I saw that you filed for a probate on this particular case. Can I sell the house? There have been situations where, people have befriended the surviving spouse, the children who they know it's public information that they're going to inherit significant assets. So we don't want everyone to be in your business and have this be part of public record and process. The other thing about probate, it's incredibly expensive. And on average, your estate would pay 3 to 5% of the gross of the estate in fees. So it would be probate fees, including attorney, executor, court filing fees. We have to pay for publication in an actual newsletter or newspaper where everybody sees that there's a probate. So we have to give notice to creditors. And then we pay taxes and creditors. At the very end, we pay beneficiaries. I just created just a simple spreadsheet of what the costs are for an average probate. So, and a $2 million probate this is something based on something we had recently on a client case where the client passed and they had a home that was worth $1.2 million. Now, the home had a loan on it, but when we're counting the probate fees, we're looking at the gross value. So the home was appraised at 1.2. There was life insurance where the beneficiary was their spouse, but the spouse predeceased them. There was no secondary beneficiary, so that also went through probate. Personal assets, including a home and some art, personal investments, and all of a sudden they had a $2 million estate. And these were approximate fees. Actually, the attorney fees, executor fees are always the same. So it was $33,000, but the fees that I included in here for $4,000, it was actually more than that because we had to pay every time we're in front of a judge, we have to pay for the court's time. We had to pay for an appraisal of the property. We had to pay a probate referee. We had to pay for recording fees, and then we had to pay for publication. So it was actually a little bit over 70,000. But you can see how expensive that can get, even if, let's say, although the value of the estate is $2 million, that does not account for a loan that may be on the property. But the probate fees are based on the gross value, even if there is a loan on the property. So I just went over, well, here's a probate, and then you're thinking, well, maybe I don't want this default estate plan that the law has written for me. What if I want to opt out of that and decide things on my own? What if I don't want the probate code to dictate who's going to receive my assets? And maybe I want to give it to my favorite charity, or I want to give it to my best friend, or make a donation, or do something that's considered to be out of the ordinary. So when you have your own estate plan, what you can do is you can decide who gets what when. So who would be, the beneficiaries you want to designate, when they will get it, and how it can be used. So instead of everything going to someone right away, you can say, I want my kids to get their funds, but I don't want them to get it until they're 30. When you change your estate plan, you can designate what happens when one spouse passes away. So that's one contingency, but also when both spouses are gone, what will happen? How your children will inherit your assets, who will be in charge of your assets and in charge of your healthcare decisions when you're incapacitated, because it's very important not only to dictate what happens after you're gone, but many times people can be incapacitated, even specifically with COVID. You, God forbid, could be in a hospital for a month or two. Who at that time can step in, pay your bills, apply for government benefits, file your taxes, and kind of deal with your everyday decisions. So in case of an emergency, who could be the person that can act on your behalf? So let's talk about what a typical estate plan would include. So just as I stated before, an estate plan is a set of documents, and it's not one document, it's a whole bunch of documents, but it's all together under this umbrella. It's called your estate plan. It's a plan of what happens when you pass away, when you're incapacitated, or if there are any emergencies. So a backbone of every estate plan, I would say, most of the estate plans we create have some kind of a trust in it, would be what's called a revocable living trust. Revocable means that the trust can be changed, and living trust means it's a trust that's created while you're alive versus a testamentary trust that's created after you pass away. So when you create a trust, the best way that I like to describe a trust is that it's a basket. So you're going to create this basket, and there are three distinct roles in a trust. People who create it, as you can see, I put a typical husband and wife family here, but it could be one individual or it could be a couple. They are the creators, or as they're also known, grantors. They're known as the settlors, the trustors. They're the people who create the trust. The creators are also people who can change the trust in the future. For most clients, you want to have a revocable trust, which means that you can change it in the future. You don't want to commit to something that's irrevocable, that if your assets change or your family situation changes, you want to be able to change it in the future. The people who create the trust will also designate a trustee or trustees. So typically, let's say if we were to take a married couple, the couple will create the trust, and while they're alive and capable and have capacity, they also will be the trustees. That means they get to manage all the trust assets. So once you create this trust, this basket, let's say we transfer your home into it, we can transfer your investment accounts into it, and you can continue to hold the assets inside the basket. The goal is, when you start this basket, I always think of my clients and telling them, we want this basket to grow. So as your assets grow, your basket grows, and you can continue to acquire future assets in the name of the trust. So once you have your trust in place, let's say you inherit a house, you buy another house, you can take it into the trust, and all of a sudden the trust becomes bigger. So the idea would be to start the trust and have the trust assets to grow. Maybe you retire, you spend some of it, but then you haven't spent all of it, that when you're gone, you pass it down to whether it's your children, it's your favorite charity, your best friend, whoever you want to pass it down to, which is the third role in the trust, is the beneficiaries. So creators, or the grantors, the trustees, people who get to manage the trust assets, and the beneficiaries, people who can benefit from the trust. So let's talk a little bit more about the trust. A typical trust, once it is created by, let's say, a couple, it will be managed by them both. They create it, they manage all the trust assets together, and they get to benefit from all the assets that are in the trust. Even if, let's say, one of them passes away or is incapacitated, the next one in line, the surviving creators, the surviving trustor, will continue to manage the trust assets for the benefit of them both. So let's say we have husband and wife. The husband becomes incapacitated. The wife can continue to manage the trust assets for her benefit and for the husband's benefit. If both of them become incapacitated, we have a successor trustee, somebody else at that point who steps in and starts managing the assets for their benefit. As long as the creators of the trust are alive, typically they are the sole beneficiaries that will continue to benefit from the trust assets. If the creators of the trust have minor children, we typically will say that, let's say husband and wife are incapacitated, but they have a minor child who's dependent on them. We can put language that says not only can they continue to benefit from the trust, but so can children or anybody who's specifically dependent on them. Okay? Let me see. What I imagine most clients who see me is that during their lifetime, we would change their trust 3 to 5 times. As I stated before, every stage of your life deserves a different type of an estate plan. So I always think of these as, let's say, one person is single, has a great job, creates a trust in place. Then that person gets married. They may consider doing a joint trust together with their spouse. They have minor children. That's an important milestone to go ahead and name guardians for the children and specific provisions in the trust for the children. Let's say the children become adults. They can come back and we can change the distribution to the children outright, or the children now can be the successor trustees. Let's say they get an inheritance. Once you get an inheritance, that's something to think about. If you get a divorce, yet another time to update your estate plan. If one spouse passes away, you may want to update the estate plan. And then when both spouses are gone, the children will be the ones to administer the trust, or some other person that they designated as a beneficiary. It is not only important to have a trust and specifically designate what your wishes are after you are gone, but really it's very important to fund the trust. Funding means putting assets in the name of the trust. So if you think of your trust as a basket, you don't want to have an empty basket. You want all your assets to be part of your basket. So for example, if the clients have a home, I will help them prepare a new deed, a trust transfer deed, where we're transferring them their home from Mary and Joe Smith as husband and wife to Mary and Joe Smith as trustees of the Smith Family Trust. So when you start getting your deed in the mail, once it's recorded, or when you start getting your property taxes, you will see that it's addressed to you as the trustees of your trust. There are other assets that actually cannot go into a trust, and that's really important to plan whether we're going to transfer everything inside the trust or whether we will have some assets live outside of the trust, but the trust will be designated as a beneficiary. An example of that would be, let's say, your 401k. Your 401k is an investment vehicle that every year when you contribute to it, you are not paying income taxes. You're deferring income taxes to a later date. As a result, you're able to put more into it, and the 401k assets continue to grow tax-free. However, when you start to take assets out of the 401k, at that point you start paying your income taxes. So if you were to transfer your 401k into your trust, just like you would transfer your house, all the taxes you deferred immediately would have to be paid because they consider that change of ownership. So it's not a good tax consequence. As a result, we want to have certain things go directly into the trust, or certain things directly go to a spouse, or maybe name the trust as a contingent beneficiary. So as part of our process of working with clients, we look at all of their assets and then figure out what goes in and what goes out. Another important thing that a lot of clients want to give away are personal belongings, and there are multiple ways of doing that. So for personal belongings, we can sit there and specifically write out gifts. My favorite niece gets my purse collection, and my son gets my grandfather's cane or my coin collection. We can either write that specifically into the trust, or we can do what's called a personal property memorandum. The trust can incorporate language that in the future you may have a personal property memorandum by which you're giving away personal belongings. So instead of you changing your mind every time and having to update the trust, I can give the clients a memorandum that's incorporated as part of the trust, and that allows them to give away personal belongings. In some situations where clients have expensive collectibles, we've also cataloged their assets. For example, we had a client whose father was a famous photographer, and he had a lot of Polaroids with famous individuals, and those were all, they were discarded Polaroids, but they were worth a lot of money. So for those, we actually took pictures of them and cataloged it as part of the trust. So depending on what kind of assets you have, how you want to dispose of them, personal belongings would also be written as part of the trust or incorporated as part of your estate plan. So let's talk a little bit about wills. And the inevitable question that I always get is, a will good enough, or should I have a trust, and what really is the difference? So a will is a document that helps you dispose of your assets. So I can write a will that says, I, Sona, being of legal age, make this will, and I'm giving everything to my husband, and if he predeceased me, I'm giving everything to my children. I can do the exact same thing in a trust. However, before the assets in my will are distributed, they still need to go through probate process. When I have a will, the assets all stay in my name and now are part of my estate after I pass away. But when I have a trust, the trust exists right now. It's a revocable trust. As a result, when I transfer my assets into the trust language will control what happens to it. And if my assets are inside the trust, then I will have to avoid probate. My estate will not go through probate. So both documents allow you to dispose of your assets. However, through a will, you still need to go, if you have it via will versus a trust, you still have to go through probate. The type of a will that we prepare in conjunction with a trust is called a pour-over will. So the essential part of this will says, if I was to pass away, pour everything back into my trust. So instead of disposing of assets through the will, it says, oh, I forgot I had an account, or I have a new asset I never put inside my basket. Pour it back into the trust and have the trust be the main vessel by which things will be distributed to my spouse, my children, etc. So the typical will you'll have in conjunction with a trust is called a pour-over will versus a standalone will that dictates who gets what. Another thing that's done in a will is designation or nomination of guardians. So if you have minor children, it's really important not only that you say specifically who gets your children's assets, how they get it, at what age, who will control it for them, but also specifically to designate who will be their guardian. Who is the person that the child will go live with, and essentially the person who will have physical custody of your child, who will make healthcare decisions for them, educational decisions for them until the child turns 18 and is of legal age. So guardian nomination is typically done in a will. However, our firm also does it in a standalone document that not only considers death, but also considers incapacity. What if a parent is permanently incapacitated? What if they have not passed away? A will is only good when a person dies. So as a result, you want to have it in both documents, a standalone guardian nomination and a will. So whenever you're designating guardians, really keep in mind, do I want to name a person or a couple? So if you are thinking of a couple, we could always say, you know, my brother and sister-in-law, but if they're ever divorced, then my brother alone, or either one of them alone, or if they're divorced, move on to the next couple. I always want a couple to handle and have my children versus one individual. It may be too much for them. So think about, you know, a person or a couple, and always think of multiple decision makers. So whether you're designating a trustee, an executor, a guardian, you always want to have option 1, option 2, and option 3. If you only give one option and that person predeceased you, can no longer act, things have changed in their lives, we're kind of back at square one. We have to go back in court and have a judge again make a determination. So as a result, I always ask for 3 options, option 1, 2, and 3. The other thing to think about is whether you want the trustee to also handle and be the guardian of the child, or do we want to separate that out? So a lot of clients will want to separate it out and have checks and balances. One person has the child, maybe one side of the family, the husband's side of the family has the child, but the wife's side of the family controls the assets. The other thing to consider is if there's a family member that you do not want to ever get your children, we specifically can also say we're anti-nominating. We're saying this person shall never get my children under any circumstances. So if they go to court and try to fight the decisions that you've made after you're gone, we have specific writing and your wishes that that person shall never be a decision maker for your children. This is especially true if, let's say, you're naming a guardian who is not a family member. I had clients who, you know, may want to change their guardian designations to their next door neighbor who they have a very good relationship with, and may not necessarily want their child to go to another state or another country where their immediate family members are located. If you want to do that, that's very important for you to note and say, I recognize, you know, these are their immediate family members, but I want somebody other than them to be the guardians. Okay, so let's talk a little bit now about documents that deal with incapacity. So the 2 big documents are the durable power of attorney, and the one I'm specifically referencing deals with financial matters. And then we'll talk in a little bit about an advanced healthcare directive. So let's say you are well, and you are, you've created your trust, you've created your will, but, God forbid something happens to you and you get COVID and you're in a hospital. And somebody needs to step in and make immediate financial decisions for you. That usually will be your agent under power of attorney. They can go to your house, open your mail, pay your bills, pay your gardener, um, collect your packages, pay immediate, caregivers, take care of your pets, sign documents that need to be signed on your behalf, maybe have access to your bank account, and kind of deal with immediate things that need to be handled right after a person is not capable of doing that. So when we create a power of attorney, we always ask our clients, oh, you know what, I switched this. Let me go back to that. When we create a power of attorney, we always ask our clients, do you want that person to have immediate access and be able to make decisions for you right away? Or do you want them only to act when you're incapacitated, which could be a very high threshold? So typically, I would say elderly clients who depend on their children, the children are very helpful and engaging in their everyday financial matters. They'll name their kids to act right away. Or married couples would definitely name their spouse to be able to act on their behalf right away. But if the client is naming, let's say, other family members, they have minor children, they're younger, they will say that the person can only act if they are incapacitated, meaning at least 2 doctors examine them and then find them incapacitated. Only then can the person act. So how do you choose your agent? And interestingly enough, when we're picking an agent for power of attorney, making financial decisions for you versus healthcare decisions, there are different things that you should consider. So for someone to make financial decisions for you, first we will look at, is this person responsible with their own finances? Are they good with paying their own bills on time? Are they savvy and smart with their own finances? So definitely pick someone like that. Are they trustworthy? Maybe you've known them a long time. Maybe they're a family member. This is not just a person who moved next door and is trying to schmooze you into, making financial decisions for you. Will they act in keeping your best interests in mind and respecting your wishes? This is especially true if you want to retain as much control of your finances as possible, and this person, whatever they do, they're going to do it for your best interest. Consider proximity to you. So if somebody is nearby and can come to your house and open your mail and pay your bills and kind of can be there for you versus they live across the country. And especially now, before getting on a plane was not that big of a deal, but due to COVID, that could be an incredibly hard thing for someone to do at this time. So you may consider doing somebody who's close to you and either your age or younger. I have a lot of my clients who are younger, who have minor children. They'll name their parents, but as the parents age, they'll come back and maybe change it to their peers or even their children who've become adults. And then consider family dynamics. If there are 3 children and you're only naming one of them to be the agent under power of attorney, how will the other kids feel? How will the parents feel? So family dynamics really play an important role when we're making decisions and choosing decision makers. I have clients who sometimes will not want to name any of their children. They'll say, I'm going to name my brother, my best friend versus my kid, so that one doesn't feel like they have more power than the other child. The other document that's incredibly important, especially right now, is an advanced healthcare directive that will specifically designate who can make healthcare decisions for you, who can advocate on your behalf, and the decisions could be things related to your end-of-life decisions, whether you specifically let them know, if I'm in an irreversible coma or persistent vegetative state, go ahead and take me off life support, and this person will advocate for your wishes. Or even in a situation where saying, I leave it up to them. I trust them to talk to the doctors to determine what is the best cause of action and care for me, and then they will they will listen to what the doctors are saying, and I trust them to make that decision for me. Whether you'd like a burial or cremation, or you may consider some other alternative way of disposing your body. I don't know if you've read the article about Luke Perry when he passed away. Rumor has it that he was buried in a thing that they call a mushroom suits that has specific pores, and it's more of a green burial that allows for growth after the person's body has been buried. So that may be something you may consider doing. Whether you want specific requests for funeral, memorial, if you want to be an organ donor, whether it's going to be your organs will be donated only for transplant purposes to save somebody's life, or you want to be using your organs for medical research, or even being a body donor. So all of these specifics will be written in your healthcare directive. And just like in the other documents, you can decide, do you trust someone to make these decisions for you immediately, or only when two or a primary doctor have examined you and found you to be incapacitated. And just like the other documents, we want to have more than one person in line, so it's not just one person, and if that person cannot act, we're back to square one. So you will have 2 or 3 options for decision makers. Another document we create as part of an estate plan would be a HIPAA release. HIPAA is the Health Insurance Portability and Accountability Act that deals with privacy of medical records. So if, as my client's attorney, if I was to contact their doctors and say, send me Joe's medical records, they would never send it to me, even if I have this, close relationship with my clients and I know a lot about them. But you can specifically designate who will have access to your medical records, who can release it to the right hospital doctor, and allow them to see it on your behalf. So when considering decisions for your healthcare directive, a little bit different than a financial person. So first of all, you want to designate somebody who's close to you, maybe a family member who can be level-headed in stressful situations, who can advocate for you, especially right now when a client goes to a hospital. The hospital will not allow family members to be there for them. So you want this person to be an advocate, even if they have to reach your doctor via, phone or Zoom or any other way to make sure that your wishes are known and they're advocating for you. Ideally, we want somebody who can live close to you or can easily be available to travel, and somebody you have discussed what your wishes are. So it's not left up to them to interpret what the healthcare directive says, but you have actually sat down and spoken with them, and they know what your specific wishes are. So those are all the documents that are part of a typical estate plan that would deal with somebody's death, incapacity, and emergencies. The last few slides, I wanted to talk a little bit about what the options are if you want to go beyond a typical estate plan and create, some kind of a charitable trust and leave behind a legacy, and what that would look like. So typically speaking, there are 2 types of charitable trusts. They're charitable remainder trust or charitable lead trusts. For example, if you have, let's say, an apartment building or an appreciated stock that is producing a lot of income, those type of assets can be put into one of these trusts, depending what looks better to you or is more relevant to you. So in a remainder trust, what you do is you put an asset into the trust. The creator of the trust is able to get an immediate charitable deduction. but they continue to keep the income for themselves during their lifetime. And after they pass away, the asset will pass to charity. So you can put, let's say, you have an apartment building that's paid off, you put it into the trust, you continue to get income from the rents. After you're gone, the building goes to your favorite charity. On the other hand, the charitable lead trusts do the opposite. What they do is during your life, they can give the income stream to the charity. And after you're gone, the asset will be distributed to a third party, like your children or somebody else that you want. They're both great vehicles for planning, depending on whether you need the income or somebody else needs the income, and what kind of a charitable deduction you would like to take. Another easy way to plan for your favorite charity would be to actually name them as direct beneficiaries. So, for example, if you have a $100,000 IRA or a $100,000 life insurance policy, and you're thinking maybe you want to make a donation of some of it, and some of it will go to your favorite niece or nephew. When you think of $100,000 IRA or life insurance, those are not equal assets. The life insurance recipient will get the life insurance policy tax-free. So if you leave that to your nephew will get the $100,000 directly in their name. However, if you leave $100,000 of your IRA or 401k to your nephew, when your nephew receives it, he would have to pay income taxes on it. So really the 100k benefit that you've left them really is maybe worth about 60 to 70,000. If you have a retirement account that you would consider giving to a charity instead, the charity can get the entire amount tax-free. So if you had $100,000 of IRA or 401k and you leave it to Breathe SoCal, then they can get the full amount tax-free because they are a 501c3 charitable organization and they don't have to pay the income taxes on it. So it's a great way when you're thinking of designating a beneficiary. That's a great way to give those income deferred accounts. Another reason why I really like naming a charity as a direct beneficiary, when a person passes away and they're designated as part of the trust, everyone who's named as a beneficiary will get a copy of the trust. But if you want maybe the trust assets to go only to your family members versus the charity to get their funds right away, you can separate them out. So you can name the charity as a direct beneficiary of your IRA, 401k, of your bank accounts. You can designate them as a transfer on death or pay on death beneficiary, and they can get the funds right away. And that could be separated out from your trust and anything else that's going to go to the family. I am finished with my presentation. Rafael, are you still there?
I am actually. Let me turn on my camera.
Mm-hmm.
See, can you see me?
Yeah, I can see you.
Okay. Well,
so, I don't know if there are any questions. Any questions you may have? Anything else I may answer?
I just want to say, wow, we're shy about a minute for 45-minute presentation. We have a Facebook question
Okay.
that says, my parents never talk about their estate plan with me. How can I break the ice with them?
That's actually a really good question. So a lot of my clients happen to be younger couples, and I hear this a lot from them that, my parents are very secretive about their money. I don't know if they're well taken care of. I don't know if I'm receiving anything. So one thing I always tell my clients is tell them that, I recently started talking about estate planning with an attorney, and she had all these questions for me. So see if you can lead by example and tell them, I've done this for myself. I want to share this with you. I've designated you as a beneficiary or as a decision maker. I would love to give you a copy. And can we have an open discussion about this? So I think leading by example always works. I've had even situations where clients have come in with their parents, and I have, kind of not necessarily advocated for the children, but said, let's put everything out in the open and have this discussion, because if you're leaving them in the dark, it's just, one of the reasons of doing this is to make sure your kids are not going and are not in the dark about this. So if they haven't, I'm assuming they haven't done anything, but if they have, it would be a great idea to say, where are your documents located? Let's talk about it, and kind of open up discussion that way.
Great. And I agree with you. I think there needs to be a conversation, and sometimes it just starts. I had a question. Can you tell me a little bit more? Have we prepared anything?
Mm-hmm.
Should anything happen? And have that conversation, an open line of communication. Another question that came in from one of our viewers is, does this trust help me avoid taxes?
It depends. So I know a lot of people are very concerned about taxes, and we don't specify what kind of taxes, right? There are lots of different taxes out there. There are income taxes, there are estate or death taxes, there are gift taxes. So depending on the type of a trust that you have. Let me just kind of step back and explain a little bit further. When I first started practicing law 15 years ago, the estate exemption was $1 million, meaning at your death, you could give away $1 million. Anything on top of that would be taxed. The current exemption is over $11 million. So unless your estate exceeds $11 million, it will not be taxed. But that number is not a permanent number. That number goes up and down depending on who's our president and what kind of tax laws we have in place. So this current tax law will sunset back to the $5 million exemption. So if you do not have an estate that's over $5 million, you're not paying any estate taxes. But one of the things you're paying is probate fees, which a lot of people equate to taxes, because it's about 3 to 5%, sometimes more, of your estate is paid in fees. So when you have a trust, it avoids probate. If you are married and you have a larger estate that exceeds $11 million, having certain type of trust can also help you avoid paying taxes until the second person is gone. Okay?
Thank you. We have another question from Brad Taylor. If I start a trust, do future generations have to keep the trust going? I'm assuming the question is putting assets into the basket.
Yeah, that's a good question, Brad. So there are different ways of giving assets to your beneficiaries. When you create a trust, let's say you're leaving your children as beneficiaries, you can say, when I'm gone, they get their assets right away, an outright distribution. At that time, the trust will cease to exist and the beneficiaries will get their assets into their name. Another way to leave funds to children will be based on some kind of milestones. I have that kind of a trust because I have 2 young daughters. So instead of them getting everything right away, they get it in stages. They get it at 25, or college graduation, and then 30, and then 35. So when they reach that last milestone, at that time, the trust will cease to exist. The third way to give money to children is in a lifetime trust, which is this generational type of trust that you're thinking about. And that one can say, I'm putting my funds in a trust, my children will be able to use it, and then when they don't use all of it, it goes to their children, and so on and so on. It becomes more of a dynasty trust. So when you create the trust, you get to decide, do you want it to end after you're gone, or do you want it to go on for small amount of time or a longer period of time?
Great. That's a great answer. And also a great question. Another question coming in through our Facebook audience is, I made a will about 2 years ago. Should I redo it?
Well, it depends. So it depends of what's changed in your life. Remember, I said when you create these documents, you're looking at what's going on in my family situation, what's going on in my financial situation, what's going on with the law. So if any of those things have changed, you may consider changing it. The other thing is, if you've just created a will, but you have assets that exceed $166,000, that threshold for probate, you may want to graduate and now create a trust. So once you create a trust and put your assets into it, you will avoid probate. So it's hard to give you an answer without speaking to you more, but look at have things changed, and do your assets now exceed or at a point where you will have to go through probate, and you want to also plan for probate avoidance.
My wife and I love revisiting our will and moving people in, moving people out, travel, you know, making sure that it's up to date. So I think I think it should be good practice for people to really, just like taxes, to pay attention to your will, see what has changed, what you've inherited, what you've acquired. If finances change, it's important to have that written down, and always to keep it updated. So.
And one of the things we do at my firm is we follow up with our clients every 3 years. We have a letter that says, you know, have any of these things happen? Because those things may trigger for them to come back and revisit. And even if we're just having a conversation, nothing's changed, it's a good way for us to stay in touch and say, you know, where are you? Is your address still the same? Where are your kids? What's going on? But inevitably during those conversations, other things will pop up that they may want to tweak or update their documents.
So. And the last question for you, Sona, is at what age should somebody contact and begin to think about estate planning, thinking about a trust?
Sure. That's a very good question. So my clients' ages span anywhere from early 20s to late 90s. And depending on what's going on with your life. So typically the clients who are in their 20s, they may not have a lot of assets, but maybe they have gotten married, they have young children, and that's the thing that prioritizes for them to go and seek an estate planning attorney. Or some of them have gotten an inheritance. So I have quite a few clients in their 20s. They will get an inheritance and they'll be very smart about it. And they'll say, you know, I really need to plan for this if something was to happen to me. So it just really depends on what's going on in your life. And every stage of your life, you may need a different estate plan. So maybe someone who doesn't have a lot of assets, they may speak to someone like me, and then they can, you know, just fill out statutory forms and just do things via beneficiary designations. I don't necessarily take on everyone who calls me if it's not the right time for them. But I think having the conversation really helps for them to know what to plan for.
Great. Thank you so much, Sona. And if any of our viewers have any questions, where should they go?
Oh, that's a good question. So actually, I'll put this up, which is my contact information. So they can always contact me at sona@linklaw.com. Our office number is there, 818-956-9200. We are on Facebook and Instagram if you want to send us messages. And I'm always happy to talk offline and answer any questions that may come in later on. I really appreciate you having me on. Thank you so much for this.
It's such a pleasure. Sona, thank you very much for a great presentation, and we look forward to many more. Thank you very much.
Thanks so much, Rafael. Take care. Bye, everybody. Bye.